When shareholders are involved in the decision-making process of the corporation, they will do so through shareholder meetings. There are annual shareholders meetings, special shareholders meetings, and we'll talk about whether you need an actual physical meeting or whether you can take shareholder action without meeting. So first, let's look at annual shareholders meetings. This is where the shareholders usually elect directors, and if there are other meetings that shareholders need to take action on, other meetings that shareholders need to vote on, then it will also happen at the annual shareholder meeting. We also have special shareholder meetings, and these are meetings where you will remove and replace directors. Remember, the shareholders have a right to remove directors if they are dissatisfied with those directors. So the shareholders can remove one or more directors. They will do that at a special shareholders meeting. There may be other matters that we will bring to a shareholder vote at a special meeting. So for example, if the corporation is going to engage in a merger and the annual shareholders meeting is still several months away and we want a decision now, we will call a special shareholders meeting to decide the matter. All right, so when you have an actual shareholders meeting, a real physical meeting, shareholders do not have to attend in person. They can attend by what we call a proxy, and we'll discuss proxies in more detail a little bit later, but attendance by proxy counts. And think of it this way. Think of not the shareholder attends by proxy, but the share is present by proxy. And we'll talk about proxies a little bit later. Sometimes you can have sometimes you can have shareholder action without an actual physical meeting. So the shareholders can decide a matter, effectively vote on a matter without having an actual shareholders meeting. And this is what we call shareholders meeting by written consent. And we'll talk about that later. All right, so one of the main rights you have as a shareholder is to elect directors and remove directors. You will elect directors at the annual shareholders meeting, and this is something where shareholders have a right to initiate action. Mostly shareholder voting rights are passive. The board will propose something and then the shareholders will vote on it. But with respect to electing directors, the shareholders can initiate action. They can nominate people to be on the board of directors. So if I'm a shareholder, I might nominate myself. I nominate myself for the board of directors, and then the other shareholders will vote on that. Removal of directors. Removal of directors, most corporate law statutes require this to be done at a special shareholders meeting. Shareholders have the right to initiate action on this as well. If I'm a shareholder and I'm unhappy with how one or more directors are performing their duties, I can propose at a shareholders meeting, at a special shareholders meeting, that they be removed from the board of directors. Once again, with respect to election of directors and removal of directors, shareholders have a right to initiate action on this. As I said just a little before, that shareholders, with respect to other matters they vote on, do not have a right to initiate action. Generally, the board will make a proposal and the shareholders will vote on it. All right, let's continue talking about shareholder voting with respect to other matters, matters other than the election and removal of directors. So shareholders only get to vote on fundamental matters. Shareholders do not vote on every business decision that the corporation makes. In fact, most business decisions that the corporation makes will not be subject to shareholder vote, even what we might call big business decisions. Now, there are a few exceptions, and we'll call these fundamental matters. The mnemonic device that I have used is MADS. You can make up your own mnemonic device. So shareholders will get to vote on mergers. Shareholders will get to vote on amendments to the articles of incorporation. Shareholders will get to vote on whether the corporation dissolves or not, dissolution, and if the corporation is selling substantially all of its assets, the shareholders will also get to vote on these matters. Once again, with respect to these matters, the shareholders have no right to initiate action. So if a shareholder thinks the corporation should engage in a merger, the shareholder has no right at a shareholders meeting to say, I propose that we enter into a merger. That's not how it works. The board of directors will propose the merger and the shareholders will vote on it. There's one other matter where shareholders get to vote, and that is with respect to bylaw amendments. But this is a little bit different in the sense that the board and the shareholders share this power. So the shareholders can amend the bylaws without approval of the board of directors. They could do it unilaterally. And the board can amend the bylaws without approval of the shareholders. The board can do it unilaterally. We'll discuss that in a little bit more detail a little bit later. All right, let's talk about vote pooling agreements. Vote pooling agreements is where two or more shareholders agree on how they will vote their shares. In the closely held corporation, this is very common. The corporation will also be a party to the agreement. Normally, not always, but normally. So two or more shareholders say, let's get together and let's vote our shares as a block. And this is how we will vote. The most important subject of a vote pooling agreement is usually how we're going to elect directors. So here's an example. Let's say that we have a closely held corporation. The shareholders are Bob, Mary, and Carol. And Bob, Mary, and Carol enter into a vote pooling agreement, agreeing to elect each other to the board of directors. Sometimes a vote pooling agreement will include an agreement on how we will vote on other matters, matters other than electing directors. What we talked about, the MADs and the bylaws, right? Mergers, amendment to the articles of incorporation, dissolution, sell substantially all the assets, and bylaw amendments. Let's talk about voting trusts. Voting trusts are similar to vote pooling agreements, but here's the important difference. This is where two or more shareholders, they actually transfer their shares to a trustee. The trustee becomes the shareholder of record. So if you look at the corporate ledger and you want to see who's the shareholder, it's the trustee, not the original shareholders. Those shareholders, those two or more shareholders, have transferred their shares to the trustee. Now, often the shareholders will get trust certificates. The trust agreement between the two shareholders and the trustee will prescribe how the trustee will vote the shares. So it's very similar to a vote pooling agreement in that the parties are entering into this voting trust so that they will vote their shares together as a block. There is an advantage over the shareholders agreement. The shareholders cannot breach a voting trust. So if we're talking about a shareholders vote pooling agreement and I agree to vote my shares in a certain way, and then at the time that I vote my shares, I decide, you know what, I'm going to breach the shareholders, I'm going to breach our vote pooling agreement, there's nothing you can do about it. You can take me to court, but at this moment, at the shareholders meeting, there is nothing you can do about it if I want to vote my shares in contravention of our vote pooling agreement. A voting trust takes my power to vote away from me and gives it to the trustee. So the trustee will vote the shares. And so if we enter into a vote pooling agreement, either one of us might breach and there's nothing we can do at the shareholders meeting. If we enter into a voting trust, neither of us will actually vote at the shareholders meeting. The trustee will vote in accordance with the instructions in the trust agreement. All right, so shareholders are not agents of the corporation. And what does it mean to be an agent? Well, an agent is someone who has authority to act on behalf of the principal. Here, the principal being the corporation. A shareholder is not an agent of the corporation. Shareholders have no right to participate in the management and the business of the corporation. Your status as shareholder alone does not give you the authority to act on behalf of the corporation and to bind the corporation to contracts. Agent authority is usually with the executive officers of the corporation, the other employees of the corporation, and maybe someone else will have authority. If a corporation gives authority to a shareholder, then the shareholder will have that authority. But you do not have authority to bind the corporation just because you are a shareholder. Later, we'll talk about agent authority in a lot more detail.